The parol-evidence rule prohibits the introduction of oral evidence that contradicts or changes the unambiguous terms of an integrated written contract. But when a contract is ambiguous, a court might consider admitting outside evidence, as happened in re Kohn. Daniel Kohn and Barbara Lutz signed a prenuptial agreement before they married in 2006. Kohn stated in this agreement that upon his death, Lutz would receive liquid assets of $3.5 million, reduced by the amounts of 4 mortgages and, quote, any accounts that passed to Lutz by operation of law, unquote. Kohn died in 2009. Lutz and Kohn's executor, Joel Hockett, disagreed on the meaning of the phrase, quote, any accounts that passed to Lutz by operation of law, unquote. Lutz argued that she'd received an immediate 1/2 interest in the joint accounts when Kohn opened them. Since she already owned half of those accounts, only Kohn's half interest passed to her by operation of law when he died. Accordingly, she thought she had to pay back only half the value of the funds in the listed joint accounts. Hockett argued that the prenup actually required Lutz to pay back the full amount of the funds in the joint accounts. He argued that as surviving joint owner, she was entitled to the full amount of the funds when Kohn died. The full accounts, therefore, passed to Lutz by operation of law and had to be paid back. Hockett sued Lutz to cover half of the amounts in the joint accounts. Lutz filed a counterclaim, asking the court to declare that the agreement read as she claimed it did. To support his case, Hockett submitted transcripts of depositions from himself and Lutz, a statement from Kohn's attorney, and letters between Kohn's and Lutz's attorneys. The surrogates court found that the disputed clause required that the payment be reduced by only half the amounts in the joint accounts. Hockett then submitted new extrinsic evidence from another deposition of Lutz's attorney. He asked the court to let him renew his opposition to Lutz's motion, but the court stuck to its original determination. Hockett appealed to the New York Supreme Court Appellate Division.